Well, hope you're all hearing me. Everybody hear me? Looks good? All right. Well, thank you for all of you for coming. As you may know, I'm A.G. Harmon, Columbus School of Law here at the Catholic University of America. On behalf of the faculty, let me thank you for zooming in to this, the first of our presentations in the Student Scholar Series. Please stay on mute until the presentation and response are over, and then I'll open the floor to questions. You'll signal that you'd like to pose a question by raising your hand in the virtual feature in the Zoom format. This series was instituted, it's amazing, 15 years ago in 2009 in order to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending that scholarship in a professional conference style setting. Today's presentation will be made by third-year student Hope Gouterman. Before I introduce Hope, a few words about the respondent to her presentation. Professor Elizabeth Kirk, who joined the Columbus School of Law after serving as the director and Kowalski Chair of Catholic Thought at the Institute for Faith and Culture at the St. Lawrence Catholic Campus Center at the University of Kansas. From 2005 to 2010, she served as the Associate Director of the Notre Dame Center for Ethics and Culture, an interdisciplinary center inspired by the teachings of St. Pope John Paul II, and dedicated to bringing the Catholic moral, intellectual, and cultural tradition to bear upon the formation of students. From 2012 to 2016, she served as a resident fellow in cultural and legal studies at the Stein Center for Social Research at Ave Maria University, and previously taught here at the Columbus School of Law in 2002 and 2003, and at Ave Maria in Ann Arbor from 2003 to 2005. She was also a clerk for the Honorable Daniel A. Mannion of the United States Court of Appeals for the Seventh Circuit from 2000 to 2002. Prior to entering academia, she practiced law representing religious and charitable organizations in the area of estate planning as well. We thank her for being with us today. I'll now introduce our student scholar, Hope Gouterman. Prior to law school, she graduated from the University of Maryland, College Park, with a Bachelor's of Science degree in Family Science, and then pursued graduate studies there, receiving a Master of Arts degree in Education. While at Catholic Law, she has been a co-lead articles editor for volume 73 of the Catholic University Law Review, a member of the National Mock Trial Team, co-wrote the 2024 Siegenthaler-Sutherland Cup Opinion, was a research and symposium assistant for the German Women Jewish lawyers in the third Wright discussion and exhibit opening last fall, and was a fellow in the Dean's Academic Fellow Program, among other distinctions. After law school, she will join Schulman Rogers, a firm in Potomac, Maryland, in their real estate department. Hope's interest in her topic was piqued by the fact that she taught third grade for 2 years at a Title I school in Montgomery County. She came across a Reuters article about a Missouri school district which had decided to implement corporal punishment as a means of student discipline, and wanted to write about the evolution of corporal punishment in schools. So I'll now turn the floor over to Hope to present her work entitled "Keep Your Hands to Yourself: A Hands-Off Plea to Reconsider the Supreme Court's Decision in Ingraham versus Wright." So, Hope, let me, I think you may have hosting duties already. See if you do, Hope, and you can share your screen. All right, let me do that. I'm going to make you the host. Okay, Hope, take it over.
Thank you. Thank you, Professor Harmon, for the introduction, and thank you for this opportunity. I'd like to start by thanking Professor Kirk, who was my expert reader and helped me last year in, the whole writing article process, has continued to help me this year in planning for this event, and thank you for agreeing to participate today. I'd also like to thank Professor Cloud, who helped me prepare for the event today. And with that being said, I'd like to now discuss my law review article and the topic of today's presentation. As Professor Harmon mentioned, keep your hands to yourselves, a hands-off plea to reconsider Ingraham versus Wright. Starting with just the abstract, This comment, or my comment, explores the Eighth Amendment within the context of corporal punishment in schools and discusses the court's decision in Ingraham versus Wright. In Ingraham versus Wright, the Supreme Court upheld the constitutionality of corporal punishment in schools and rejected the Eighth Amendment applicability to such disciplinary action. The comment starts by exploring the historical context of cruel and unusual punishment within the Eighth Amendment, and the use of corporal punishment within US public schools. It also provides a stare decisis analysis if the Supreme Court were to reconsider the Ingram's Eighth Amendment holding. It acknowledges the ramifications of Ingraham and urges the court to, in fact, reconsider the Eighth Amendment decision. So starting with just a brief overview of the history of the Eighth Amendment. In 1689, England prohibited cruel and unusual punishments. Then in the Massachusetts Convention of 1788, framers were worried about the lack of limitations that Congress appeared to have in determining punishments for crimes. They were concerned with the use of tortures and other barbarous methods of punishment and feared that the new wielding power that Congress had would be actually used to be a tool for oppressing people when determining cruel punishments. In 1791, 3/4 of the states ratified and adopted the Eighth Amendment, and then similarly, it applied to the states between 1866 and when ratification was complete for the 14th Amendment in 1868. The Eighth Amendment reads, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." And the focus of my article is on the last clause, the cruel and unusual punishments clause. Turning now to a little bit of history about the corporal punishment in schools generally. As early as 1837, the North Carolina courts determined that schools were in effect acting as substitute of parents, which meant that they had the duty to be able to train school children to be members of society. And they determined that this couldn't be done without the ability to use corporal punishment as a disciplinary tactic. In 1890, an Alabama court imposed limitations. A teacher will not be permitted to inflict cruel and merciless punishment, which sounds very similar to the Eighth Amendment cruel and unusual punishment clause. And then as recent as 2010 and more previous cases have talked about, to determine whether or not corporal punishment is reasonable, a court must ask whether the use of force is related to the student's misconduct, meaning is it proportionate to what the student did wrong, and inquiring to the purpose of the discipline. And so corporal punishment is defined as the infliction of bodily pain as a penalty for disapproved behavior. And to constitute corporal punishment, the act in question must be corporal in that it inflicts pain on the physical body of the victim, and punishment in that the intent of the actor is to punish the person receiving. And as Professor Harmon mentioned, my why. So in August of 2022, I read an article that discussed how a Missouri school district was bringing back corporal punishment as a disciplinary method in their schools. And given my background in education, I thought this would be a perfect way to marry education with law. So now turning to the Supreme Court decision in Ingraham versus Wright, which is the bulk of my article, to give you a little bit of context as to the facts of Ingraham versus Wright. It primarily focuses on 2 students in middle school who received corporal punishment. The first student was James Ingraham. James Ingraham was too slow in leaving the stage of a school auditorium, and he was asked to do so by a teacher. He then refused to be paddled, and because of this, the principal, who was helped by 2 assistant principals, held James by his arms and legs, placed him face down across a table, and administered at least 20 licks or paddles. Because of this, James suffered a hematoma to his back. He was prescribed pain medication and sleeping medication, and he was in pain for 3 weeks following the incident. The second student was Roosevelt Andrews. And as Roosevelt was walking through the hallway, he was stopped by a teacher. And the teacher told him that he wouldn't be able to make it to class on time. So the teacher then brought Roosevelt to the assistant principal. The assistant principal told Roosevelt to go into a bathroom where there were roughly 15 other boys who were lined up against the urinals, and the assistant principal paddled them. On another occasion, Roosevelt was blamed for breaking glasses in a sheet metal class, and during that incident received another paddling, at which time his wrist was hit. Because of this, he received medical treatment for his wrist. He was prescribed pain medication, and for 1 week was unable to use his arm. So in this instance, the Supreme Court ultimately held in a 5-4 decision that when public school teachers or administrators impose disciplinary corporal punishment, the Eighth Amendment is inapplicable. But where school authorities who are acting under the color of state law deliberately decide to punish a child for misconduct by restraining the child and inflicting appreciable physical pain, substantive due process under the 14th Amendment did apply. The child's liberty interests were implicated. The court then determined that under procedural due process, that students were not, it was not necessary to provide notice and a hearing to the students prior to administering corporal punishment in public schools because of the safeguards provided and limits imposed in common law. So when I was writing this article and determining how to structure, I was looking at how other Supreme Court cases would review in deciding whether or not to reconsider their prior precedent. And in doing so, I decided to structure it as a stare decisis analysis. And stare decisis is the doctrine of precedent where a court has to follow their earlier decision when the same points arise again in litigation. So the first consideration in a stare decisis analysis is whether or not the Supreme Court got it egregiously wrong. And at the time when I wrote the article, the most recent Supreme Court decision doing a stare decisis analysis was in Dobbs. So the court recommended in Dobbs to look for whether or not they got it egregiously wrong was the Plessy versus Ferguson case. So, where Plessy versus Ferguson said that separate was equal, in hindsight, after reconsidering, separate was inherently unequal. So with that backdrop, looking at what the Ingraham court determined, I want to focus on whether or not they got it egregiously wrong when they compared a school child to a person in prison. And the court found that the school child does not need to be afforded the protections of the Eighth Amendment, while a person in prison does. And in doing so, first, the court articulated, though attendance may not always be voluntary, the public school remains an open institution. The court went on to say, except perhaps when very young, the child is not physically restrained from leaving school during school hours, and at the end of the school day, the child is invariably free to return home. Finally, the court said that even while at school, the child brings with him the support of family and friends and is rarely apart from teachers and other pupils who may witness and protest instances of mistreatment. And my pushback was that, first, as the court acknowledged, there are now mandatory attendance requirements. And then with the third part of the court's opinion, Ingraham specifically contradicts what the court was saying in that both of the students who received the corporal punishment, James and Roosevelt, were at one point in front of other pupils and were in front of teachers who led them to the corporal punishment infliction. In fact, with James's circumstances, the assistant principals helped the principal inflict the corporal punishment. And so to say that there will be instances of protest is not exactly accurate as shown by Ingraham. And in comparison, a prisoner's conviction deprives him of freedom to be with family and friends and to form other enduring attachments of normal life. Against this, the Ingraham court determined that the school child can seek protection under the 14th Amendment when a school staff member's imposition of corporal punishment is so excessive as to shock the conscience. And you can almost see the identical language in the 8th Amendment application to a person who is in prison, where the protection under the 8th Amendment when an agent of the state committed an act as punishment shocking the conscience. So the next part of a stare decisis analysis is the quality of the court's reasoning. And again, looking to the Dobbs court to kind of guide me through the stare decisis analysis, the court explained that in Planned Parenthood versus Casey, things to look for in determining the quality of the court's reasoning would be the text, precedent, history, and a consensus of other state laws. So against that guidance, I looked at how Ingraham reasoned, the court in Ingraham reasoned, and they identified the text saying that bails, fines, and punishments within the 8th Amendment traditionally have been associated with the criminal process. They also explained that the reference to criminal cases was eliminated from the final draft of the English Bill of Rights, and the preservation of a similar reference in the preamble indicated that that deletion was without substantive significance. And my pushback is that the text of the 8th Amendment does not only associate with the criminal process, unlike the 6th Amendment that explains or uses the terms in all criminal prosecutions. That's not evident in the 8th Amendment. And so also the fact that the 8th Amendment was mirrored off of the English, what the people in England did, if they knew that that was eliminated from the final draft of the English Bill of Rights, the framers also knew how to put it into the 8th Amendment, but didn't. For the history, the court explained that it was designed to protect those convicted of crimes. And then the consensus at the time, the court held that every decision of the Supreme Court in considering whether a punishment was cruel or unusual determined it within the context of criminal punishment. And at that time, only 2 states, Massachusetts and New Jersey, had prohibited all corporal punishment in their public schools. And it's my position that today that is not the case. The consensus of the states, the majority of states now prohibit corporal punishment in public schools, and that trend seems to be increasing as well. The next consideration in the stare decisis analysis is the workability of the rule. And the Dobbs court explained that looking to whether or not it's workable, an example of where it's not workable would be in Casey, the undue burden test. And so against that backdrop, in looking at the Ingraham court explained that while reasonable corporal punishment is allowed, where the use of force is so excessive as to shock the conscience of the court, then the student can sue by alleging a violation of the 14th Amendment, their substantive due process rights. And taking those in turn, first and foremost, what is reasonable? Is it from the lens of a student receiving the corporal punishment, or is it from the teacher imposing or the authority figure imposing the corporal punishment? That creates issues. And then courts have also had difficulty drawing the line of where use of force becomes so excessive as to shock the conscience of the court. The next consideration is the effect on other areas of law. So in Dobbs, the court explained that there were problems that arose in First Amendment context, third-party standing, And so it did upend some of the effects on other areas of law. And similarly, after Ingraham, especially in the criminal law context, there were problems that arose because of Ingraham. In fact, a circuit split issues arose as to whether the Eighth Amendment was applicable to the criminal process entirely or was limited to simply post-conviction. So questions arose asking about whether pretrial detainees could seek protection under the Eighth Amendment. If someone had been charged but not convicted, were they allowed to seek protection under the Eighth Amendment? And similar standing issues arose as to whether or not they could seek protection under the Eighth Amendment. And then the final consideration in the stare decisis analysis is reliance interests. And the court in Dobbs explained that what we're looking for is concrete reliance interests, meaning those like found in contracts and property cases, as opposed to procedural and evidentiary issues. And so looking to, whether or not there are concrete reliance interests on Ingraham, there are. The authority in schools who are able to impose corporal punishment not only rely on Ingraham, but also rely on, history itself. And since the 1830s, as I mentioned, in North Carolina, to be able to impose and inflict reasonable corporal punishment in schools against what they would call unruly school children. And similarly, in terms of just corporal punishment as a whole, parents are able to impose reasonable corporal punishment on their children. Now, on the flip side, the empirical questions and procedural rules that, of course, the court recognized as not as strong and not concrete reliance interests, but in my view are still worth mentioning, would be the difficulty in assessing the effect on the right of a particular student in school to be free from corporal punishment. And while we have social science data and trends, it's difficult to see the effects of the corporal punishment on an individual school child. And then also the difficulty assessing the effect of the right to both inflict corporal punishment as well as to be free from unreasonable corporal punishment in schools that effect on society. And so if the court were unwilling to reconsider Ingraham, then there are other ways to still accomplish the goal that my article and I support, which is prohibiting corporal punishment in schools as a means of discipline. So for example, Protecting Our Students in Schools Act of 2023, the first objective is to prohibit corporal punishment in schools. And then in the Bipartisan Safer Communities Act of 2023, the Department of Education explained that they were not aware of any evidence that restraint or seclusion is an effective strategy in modifying a child's behavior. So the whole point of imposing reasonable corporal punishment in schools is negated by a 2023 US Department of Education, admission that it's not an effective strategy to modify the child's behavior. Similarly, in a July 19th, 2022 letter issued by the Department of Education, Office of Special Education and Rehabilitative Services, found that in-school corporal punishment is often not applied equally to all students and is disproportionately applied to students of color and students with disabilities. Use of corporal punishment is ineffective as a strategy to address inappropriate behavior and is also associated with negative academic outcomes. So similar to the Bipartisan Safer Communities Act of 2023, reflecting that, in fact, it doesn't accomplish the goal it set out to accomplish. And so just taking the argument full circle, the whole purpose for passing the Eighth Amendment and the idea behind it was to ensure that there was some type of limit on Congress's ability in their position of power to impose punishments. Similarly, authorities in schools are in a position of power when they're imposing corporal punishment on students. And so that is why I was urging, and I'm still urging the court to reconsider the Ingraham holding, making the Eighth Amendment apply in a school context. Thank you.
Thank you, Hope. I will now turn things over to Professor Kirk. Professor Kirk, if you'll unmute and conduct the response.
Sure. Well, first, let me just congratulate Hope on that presentation and on a fine paper. Just first want to say what a delight it was to work with her on this paper, and also to have her in class. She, as you can tell from her presentation, is very diligent and thoughtful and curious, which is such a wonderful quality to have in a student, someone who's intellectually curious. And also, I think Hope has a kind of rare quality in academic circles, which is this really strong sense of intellectual humility. So as her paper evolved, Hope kind of continually challenged herself, her own understanding about the topic, her own, original conceptions, etc., but worked to be intellectually rigorous, right, as she worked through her legal arguments. So very impressive student, and just so eager to see how her career develops. So in our response time that we have here, I just wanted to ask maybe a few questions that might allow Hope to elaborate a bit on some of the points that she already made. So the first one is this interplay between the Eighth Amendment and the 14th Amendment. So to be clear, you're not suggesting in your paper that corporal punishment is per se unconstitutional under the Eighth Amendment or any other provision, right? But rather just that the Eighth Amendment should apply to constrain its use. You also noted in your paper that the 14th Amendment already limits the scope of corporal punishment, and you draw parallels between the shocking the conscience and the cruel and unusual rubrics or frameworks, right? So can you explain a little bit more why the 14th Amendment requirement that punishments be reasonable isn't sufficient to protect children, and why you think the Eighth Amendment would be a better source of protection for children?
Thank you, Professor Kirk. Yes. So from the onset, when I was looking at the issue between the 8th and the 14th, my initial thought was that the 14th Amendment substantive due process, as it relates to especially, a liberty interest like the one at stake here, is not necessarily, I guess I could say it's not enumerated. So it's not an enumerated right, which is why I thought a stronger protection could be found in the Eighth Amendment, because it is enumerated. But as you mentioned, as we discussed, and after, grappling with all the issues that go into both the Eighth and the 14th Amendment, I think I realize and can reflect that that might not necessarily be the case. In fact, the 14th Amendment might actually provide more of a protection and maybe less of a hurdle for school children to get over than if the Eighth Amendment did apply. And I say that because the Eighth Amendment, when I researched, has both an objective and a subjective inquiry. And in that inquiry, it specifically doesn't allow, for example, not just uncomfortable, it says, or even harsh deprivations, but they have to be cruel and unusual. And if the precedent that we're working off of is from the lens, the objective view of those receiving, cruel and unusual punishment in the context of prisons only, then it might be more difficult for a school child to satisfy even just the objective inquiry. So I think after kind of reflecting back, which I think is okay, that I'm able to see kind of both sides a little bit more clearly now, it might not be the case that the 14th Amendment is insufficient. It's just my understanding that because the Eighth Amendment is enumerated, it does, historically provide that, I guess, safeguard as opposed to a substantive due process right, which might not necessarily be as safe, so to speak.
Yeah, that makes sense. Could you explain a little bit more about the Ingraham Court's reasoning? So its conclusion that corporal punishment in schools was not prohibited by the Eighth Amendment rests in part, as you explained, on its conclusion that that amendment only applies to the criminal context, right? And that the dicta about how school children are not similarly situated to prisoners kind of reinforces that, but their primary conclusion was this kind of historical understanding. But could you explain a little bit about the kind of broader interpretation of the Eighth Amendment, that it wasn't about criminal per se, but punitive, right? The difference between the criminal context and just any context that would be punitive?
Yeah, so the dissent talks a lot about this too, because obviously they're kind of going against what the majority is saying, in that the language, the plain language of the text of the Eighth Amendment doesn't say anything about, criminal context only, but says punishment. And so part of the rationale would be that, well, if it just says punishment and the intent just has to be punitive, then somebody in a position of authority at school who is imposing corporal punishment on a school child, is in a position of authority and is imposing a punitive punishment, so that the school child, will be rehabilitated or will not repeat those behaviors. So I think that it's mostly ingrained within the text itself of the Eighth Amendment.
All right, so shifting slightly, another point you make in your paper is that the early understanding of the school's authority, or at least the practice of imposing corporal punishment, was understood to be a kind of delegation of power from parents, right? A sort of in loco parentis or delegation argument. And of course, in all 50 states, parents have the authority to discipline their children, including through the use of corporal punishment. But interestingly, in Ingraham, the court says that the contemporary view of why schools can use corporal punishment is actually that the state has the primary authority, that it's not derivative of parents, to impose corporal punishment for the education of children and to maintain order or discipline. Can you speak there to the interplay between parental rights and the authority of the state, and whether Ingraham got that part right?
Yeah, so as you mentioned, in Ingraham, they explained that the state has an interest in carrying out, a school day without being overly interrupted by a child, and that would be the rationale for why parents aren't necessarily involved in consenting to whether or not their child can receive the corporal punishment. And on one hand, I can understand the state interest, and in fact, in Ingraham, the policy at issue specifically said that only upon request by the parent would the person or the authority figure imposing corporal punishment have to provide them with some type of written explanation. So the parents were playing more of a hands-off role in that regard. On the flip side, I also think it raises some issues to parents' ability to, as in Pierce versus Society of Sisters, they have the right to determine the child's upbringing. And similarly in Myers versus Nebraska, the right to educate the child is with the parent. So I think there's two competing views of balancing the state interest that Ingraham supports versus the parent's authority and liberty interest at stake too. And I think it's just a comparison at this stage, but I do think that it's important to note that moving forward and how more recent states have determined the parent's role in this corporal punishment aspect in schools is that they're moving toward, if not prohibiting it altogether, toward needing parental consent before proceeding forward.
Yeah, in fact, you and I noted earlier this week that the Florida legislature is currently considering a law that would place additional restrictions on the school's ability to impose. I mean, still allowing schools to do it, but impose additional restrictions. For example, sort of cabining the students to whom this punishment could be meted out. So, for example, students who have IEPs or students who have certain disabilities would, there would be a blanket prohibition on corporal punishment against such students. But another feature of the law would require the written permission of the parents. So under this law, only the principal can impose it. So it can't be the sort of heat of the moment teacher imposing it. Only the principal can impose it, but the teacher would first have to check their file, right, to make sure the parents had signed off on allowing this punishment. Do you think that strikes the right balance between the competing interests you described?
I think obviously I would want to go one level further in the full prohibition, but I think that it does afford, kind of as the dissent talked about, when the majority said that, you don't need a formal notice requirement and hearing requirement. I think it strikes a balance because it allows a cooling off period, because it will take time for the teacher or the authority figure to figure out whether or not the parent allowed the child to receive the corporal punishment. And so, coming from a purely practical standpoint, if they have to take the time to look it up, that might provide more of a cooling off period between both the teacher or the authority figure and the child, and perhaps even an opportunity for the child to explain themselves or for the authority figure to explain themselves. Because I think the tension between the majority and the dissent in affording due process was that neither party really had time to explain each side. It was more an impulsive decision at the time. I see you doing something, I'm going to inflict this corporal punishment on you.
Yeah, I mean, the court in Ingraham, of course, rejected the idea that the Constitution, the 14th Amendment, requires that sort of process, right? That would allow that cooling off period, whether a notice or hearing or even something short of that, like it has required in other contexts for children. So one of the things that I really found interesting, and I learned a lot in working, with you on your paper, was just, the social science behind the use of corporal punishment. You don't focus on it as much in your paper, although you mention it, but the court in Ingraham noted that many would welcome, right, the elimination of corporal punishment as a societal advance, but said that sort of determination had to be left to the democratic process, given its conclusion about the Eighth Amendment. But you did a great deal of research on the use and the efficacy of corporal punishment. You mentioned the Department of Education reports in your paper. So if you were advising the Florida legislature, right, like this doesn't go far enough, you need to ban it. What more would you share with them that would aid in their deliberations regarding the use of corporal punishment?
Yay, good question. Thank you, Professor. So I guess I would start by saying that, as recent as 2017 and 2018, there are still 69,000 and almost 500 students receiving corporal punishment in schools, which over the country might not seem like a lot, but to still be imposing this as a disciplinary measure is extreme. And I also think that the disproportionate populations who are affected by it is a strong reason to move away from it. For example, Black students were 2.3 times more likely than white students to receive corporal punishment in 2017 and 2018, and that's a problem. And similarly, students with disabilities served under IDEA represented 13.2% of the student enrollment, but 16.5% of those receiving corporal punishment. Again, a disproportionate impact on those who are minority populations who need to be bolstered as opposed to inflicted with corporal punishment. And then, as early as March of 2023, there are only 23 states who still allow corporal punishment in schools. So the fact that a majority have moved away, even though it's expressly allowed in Ingraham would tend to show how it's ineffective as a way to deter behavior and modify behavior in schools. And I think that the alternatives, positive behavioral intervention systems, other ways of showing students this is not okay, but also listening to students as a part of that measure, I think is more effective, because you learn who the child is at a more critical level, and you're able to understand why something happened, as opposed to just the fact that something did happen.
What's the international kind of trajectory on this issue?
Yeah, so internationally, I want to say it's roughly 50, internationally states, quote unquote, have eliminated the practice altogether. And in fact, there's a treaty designed to prevent this. There are also a host of advocacy groups that are purely in existence to reject corporal punishment in schools and generally.
And generally including parents.
Yes.
Use of corporal punishment. Yeah. Fascinating. I think that's our 10 minutes. So Professor Harmon,
We'll close. I want to thank Professor Kirk for taking her time out today, and especially thanks to Hope for starting off the series this year with such a great contribution. I also want to applaud her efforts, and she was one of my TAs and has been one of our Siegenthaler writers this year. And as Professor Kirk said, someone who's inquisitiveness or in her intellectual, she put it as humility, and I want to say her honesty about things. And she, regardless of where she may come down on something, she's always interested in the other side of things, and she wanted to be fair. And her approach to that is a rare thing. And she doesn't come in with all the answers already. She wants to find the answers, and that's a remarkable thing, to have that kind of intellectual humility. Honesty is something we all strive for. So thank you, Hope. Thank you for a great contribution, and we will do this again. Well, we're yet to find a date yet, but we're gonna do this again next month with Isabella Kolyetsi. So I'll write to you and let you know when that program's set. So thank you all for coming today.